The public protector has maintained at the Constitutional Court that President Cyril Ramaphosa misled Parliament. Her legal representative argues that the case against Ramaphosa is of exceptional circumstances, making it worthy of a direct appeal to the Constitutional Court. Mkhwebane is appealing a High Court order ruling that dismissed her report. This was into Ramaphosa's CR17 campaign funds ahead of the ANC's elections, which saw him beat former President Jacob Zuma. She found that Ramaphosa had deliberately misled Parliament when he was asked about Bosasa donating 500,000 rand towards his ANC presidential campaign. However, the Constitutional Court judges have questioned if it was deliberate after he admitted and apologized for giving Parliament the wrong information initially.
My submission on that score is simply that if one looks at we phrase it as the importance of the matter, but I suggest that I submit that it is exceptional in the sense that even if it's not important, the nature of the functionary is not important, but we suggest that, as I said earlier, what I call the clash, and I don't mean personally, but I suggest that the clash between the head of state in relation to the extent or the standard to which he must be heard, and how far the public protector can go to deal with the head of state and the nature of his or her accountability. In our submission in this case, is a matter this court must consider exceptional. It may not be exceptional all the time that a case between the PP and the president are exceptional. I'm not suggesting that at all. I'm suggesting that if one looks at this matter, it deals with a breach, a possible constitutional breach of the function, which is Section 96. And if we are wrong that it was a breach, we are wrong. But our submission is that it's the matter of a breach by the president, a possible breach of Section 96 of the Constitution, and the deputy president, as he then was, is an exceptional matter.
Meanwhile, Ramaphosa's lawyer, Wim Trengove, has described the funding report as a reckless attempt to nail the president. He accused Mkhwebane of making mistakes that no lawyer acting in good faith would.
That the public protector made two very obvious errors. Frankly, errors so obvious and so patent that no lawyer acting in good faith could have made those errors. And they were, in the first place, that she misread the applicable provision of the code, that's paragraph 2.3a, misread it badly. And not only misread it, but quoted a variety of renditions of the same provision, which is a symptom of recklessness of an appalling kind. But then the second is that she conflated the concepts of deliberate or inadvertent conduct, or as lawyers would say, willful or negligent conduct. Also a confusion so basic that a good faith lawyer could not have made that mistake. We submit that both these mistakes are symptomatic of a reckless determination by the public protector to nail the president. And that is relevant not only to the merits of this review, but also to the order for costs that you would make.
Trengove denies that Ramaphosa misled Parliament when answering a question from then DA leader Busisiwe Mkhwebane.
The President never misled Parliament. The fact of the matter is that Mr. Mkhwebane told the President that he had sworn evidence that a payment had been made to his son. That was Mr. Maimane's premise upon which he based his question. And he gave that information to Parliament. If anybody made a mistake, and I'm not going to accuse him of misleading Parliament, but if anybody made a mistake, it was Mr. Maimane. But the premise on which the President was asked to answer the question was the given premise that an amount of Mr. Watson had paid an amount of 500,000 rand to the President's son. And the President was asked to explain how come Mr. Watson pays these large amounts to his son. And the President had discussed his son, his relationship with Mr. Watson. He knew that money had flowed from the one to the other, and he confidently gave that answer, perfectly honestly. Can you imagine if he realized that this was a mistake, that this was not a payment to his son, that this was a donation to CR17? Of course, he would have said so. It's far easier to explain. But because he is understandably and in good faith under the impression that we're dealing with a payment of the kind described by Mr. Maimane, and that's a payment by Mr. Watson to Andile Ramaphosa. It's on that premise that he gave the answer he did.
While staying with matters now concerning the Public Protector, National Assembly Speaker Thandi Modise has announced the names of the 3-member panel which will decide if Busisiwe Mkhwebane is fit for public office. It will have 30 days to report back if she is guilty of misconduct. We're joined by the DA's Chief Whip, Natasha Mazzoni, who championed the motion to institute removal proceedings against Mkhwebane. Natasha, good evening and thanks for your time. Firstly, what are your expectations of this panel?
Well, Kathy, thank you so much for having me, and I'm delighted that this panel has been established and that the Chief Whip, rather the Speaker of Parliament, has established the panel. I think it's a very high-level panel of very respected legal minds in our country, and I think that that will go a long way in ensuring that the whole process is transparent and fair. What this particular panel will do is they will have 30 days in which to decide whether or not my motion gives enough prima facie evidence to Parliament to institute a motion of no confidence in the Public Protector. So they have a mammoth task ahead of them. They have a short amount of time in which they will be allowed to finish their work. And once they start, it's a 30-day period until they report back to Parliament. So it will be quite fast-paced, but I'm incredibly delighted with the level of legal expertise that we have in this particular panel.
Do you still hold the view that the Public Protector is incompetent and shouldn't be in that position?
I think that the Public Protector has been judged very much by her peers in terms of court rulings that have come out against her. And I think that judges have declared very clearly the shortcomings that the Office of the Public Protector and the Public Protector herself have brought out in many of her findings. For me, what is essential is that the Chapter 9 institution that holds the importance, such as the Office of the Public Protector, is protected itself. And it's my number one concern to reinstall and reinstate the Public Protector as the very top level Chapter 9 institution that South Africans have full faith in, and that certainly as Parliament we have faith in when we report issues to the Public Protector.
Of course, when it comes to matters of law, the case that is before the Constitutional Court is going to be significant if the Constitutional Court perhaps finds in the favor of Advocate Mkhwebane and her lawyers. Do you think that it might be premature for this panel to do its work before a significant case such as this one is actually concluded before the Constitutional Court?
Well, Kathy, what makes the parliamentary procedure so fair is that I'm not allowed to add information to my initial charge. If I want to, I have to withdraw the motion and I have to resubmit it. And that's what I did last year, in actual fact. I submitted my first motion and then a significant judgment came out and I felt that it would be right for the panel to have that information and I submitted a new motion. I am of the opinion, and as is the DA, that we have significant and sufficient information motion now for the panel to make a decision on whether or not there is prima facie evidence to hold the public protector to account for, whether or not she should face the motion of no confidence. So this particular judgment is neither here nor there, because according to the rules of Parliament, I couldn't submit the finding of this court to my evidence even if I wanted to.
Speaking of motions of no confidence, we know that the National Assembly is going to be hearing a motion of no confidence against President Cyril Ramaphosa. It's been put forward by the ATM. What are the chances, Natasha, that your party is going to be supporting them?
Well, I think it's well known to the South African public where the ATM stand. They're a faction that's been backing a certain faction within the ANC. It's doing a little dirty work for an ANC faction that doesn't want to do the work themselves. And certainly we think a frivolous motion brought by a party just out to do the ANC's dirty work for them. So quite frankly, a waste of Parliament's time at this stage of the game. There is drastically important work that needs to be done, and the ANC faction should find another place to do their internal bidding other than the floor of Parliament.
The DA's Chief Whip, Natasha Mazzoni, let me thank you for your time on News at Prime tonight.